Hello everyone, this is Snigdha Mohapatra, an intern at LEXCLIQ. In my previous video, I had talked about the meetings under company law and the various types of meetings. In this video, I will be talking about the procedure of meetings. All the meetings have a definite procedure which is to be followed while conducting such a meeting. It is the responsibility of the director of the company to ensure that the procedure followed for conducting the meetings of the company is valid and in accordance with the Companies Act. The decisions that are taken in the meeting should be according to the sections of the Companies Act. It is the duty of the director to ensure that the members of the meeting are notified of the details of the meeting, like the place, time, and date of the meeting, type of the meeting, and the business that will be considered and discussed in such a meeting. And the notice should also include motions and resolutions that will be put forward to the members during the meeting. It is important to confirm that there is a quorum present before the meetings commences, and it is also important to ensure that the quorum is maintained during the process of the meeting, as it is necessary for a valid motion to pass. A meeting must be chaired by a chairperson. The chairperson is responsible to control the proceedings of the meeting. He introduces and concludes the meeting. The chairperson has to ensure that proper notice is served to the members of the meeting and go through the minutes of the meeting. He ensures that the meeting takes place and gets over within the time prescribed for it. He keeps order and facilitates the meeting, ensures everyone gets an equal opportunity to share their views and be heard. The chairperson receives motions and puts a vote on such motions. In case of a tie, the chairperson has to cast a final vote and declare the result. Now, what are the various procedures for a meeting? First is notice. A notice of a meeting is served to all the members of the meeting to discuss the business. A notice is to be served to the members in a manner which is subscribed in the Companies Act. Notice for the general meetings must also be served to directors, auditors, and to any such member who is entitled to a share in case of a member of the meeting dies. In case a company accidentally fails to serve a notice to a person who is entitled to receive it, the meeting should not be considered invalid. All the members of the meetings are entitled to vote in the matters raised in the meeting. The contents of the notice depends on the type of meeting which is called for. If the company has called for annual general meeting, it will include all ordinary business which will be discussed in the meeting. And if extraordinary general meeting is called by the company, then the notice will include the special business and resolutions which will be discussed in the meeting. Annual general meeting needs a notice to be served to the members of the meeting in advance of 21 days, whereas in the extraordinary general meeting, a notice is needed to be served in advance of 14 days. Now, what is the contents of notice? The notice must contain the following contents. First, place where the meeting will be conducted. Second, date and day and time on which the meeting is to be conducted. Third, the business which will be discussed in the meeting. Fourth, the brief of the business. Fifth, the date on which notice is served. And sixth, signature of the convener of the meeting. In the case of Parker and Cooper Limited versus Reading, it was observed that when the notice which was served to the members of the meeting is improper, but still the members of the meeting attend the meeting, then the notice can be made good and the meeting can be considered to be a valid meeting, irrespective of the fact that whether the notice which was served for the meeting was proper or improper. Now, one of the most important procedure or constituent of a meeting is quorum. Section 103 of the Companies Act lays down the quorum which is required for the meeting. The quorum refers to the minimum number of members required to conduct a meeting. According to Section 174 of the Companies Act, one third of the total number of members to the meeting constitutes a quorum for the meeting. In a meeting, a minimum of two directors are required to attend the meeting, but where the company is owned by a single person, then in that case the condition does not apply. According to Section 174, subsection 1 of the Companies Act, it is possible for a director to attend a meeting through a video conference call. A director attending a meeting through video conference call will also be considered while counting for a quorum. Now, the next part is chairman. A meeting is chaired by a chairperson. The chairperson is also known as the chairman and is responsible to control the proceedings of the meeting. He introduces and concludes the meetings. The chairperson has to ensure that proper notice is served to the members of the meeting and has to go through the minutes of the meeting in the last. He keeps order and facilitates the meeting. It is the duty of the chairman to ensure that each member of the meeting gets an equal opportunity to share their views. The next part is voting rights. In case there is a matter which needs to be decided on in the meeting, it is done by the votes of the members of the meeting. According to section 50, subsection 2, every member who is limited by company shares and holds equity share capital will have a right to vote on all the resolutions which lie before the company. Section 188, subsection 1 of the Companies Act states that the members who are entitled to vote shall have voting rights on a poll in proportion to the shares held by him to the paid up equity share capital of the company. Now, the next part is resolutions by postal ballot. According to Section 110 of the Companies Act, a postal ballot is a method of voting which is used when a member who is entitled to vote cannot be physically present to vote. In such a circumstance, the member who is entitled to vote can send his vote by posting it. Postal ballot refers to the method of voting by post. This method enables members to vote who otherwise would not have been able to because of their physical absence. The vote can be sent through a registered post, courier service, speed post, or by electronic means such as mail. Postal ballot cannot be used in case where a company is a one-person company or in case the company has up to 200 members. Now, one of the most important means of voting for a resolution is electronic mode. Voting for a resolution by electronic mode means casting a vote by electronic voting. Voting by electronic mode includes voting by punched cards, optical scan voting system, and specialized voting kiosks, telephones, private computer networks, internet, etc. Section 108 of the Companies Act includes a provision for electronic mode of voting. A company listed under the Companies Act 2013 having 1,000 or more shareholders should provide to its members the facility of casting vote through electronic mode. A member gets the right to vote even if they are not physically present in a meeting through electronic modes. The electronic mode of voting can be used in a place of the postal ballot. The electronic mode of voting is more convenient and, of course, time saving. Thank you so much for watching the video and please subscribe to the channel.